Welcome, everyone. We have closed caption below. If you have any questions over the course of this webinar, please pop them into the Q&A. If you go to the bottom of your screen, you'll see that there's a Q&A box, and you can put questions in there, and we'll address them at the end of the presentation. And Michael will come back on screen and read them out at the end. So without further ado, I will pass it on to you both. I know you have a PowerPoint that you're going to share, and I will go off camera and watch. Thank you so much for being here.
Great. Well, thank you so much for having us. It's a pleasure to present today. And what we will try to do is to give you an overview of immigration rules as they pertain to sponsorship for employment, and then also for family-based sponsorship. Now, the world of immigration is quite complex and huge, and what we're trying to attempt to do in this hour is really just give you a basic understanding of two facets of immigration. Now, as far as today's talk, it's important to know that whatever information we provide is not legal advice. This is not the appropriate forum for us to provide any kind of legal advice on a personal basis. And all the questions that you ask us, they'll be public. So it's really important to not divulge any kind of personal information during the Q&A. And that's just to preserve privacy. And we'll provide our email addresses later. So if you have questions to follow up, of course, you can ask us, and we're happy to address those. Now, today's agenda is really just an overview, like I said. We're going to talk about the basic immigration system, some of the non-immigrant categories that are available for employment-based sponsorship, and then we'll talk about the green card pathways, and Madeline will give you some really good advice about that. Now, the basics, and this is the real basic, the US immigration system basically divides the world into two. You have US citizens and everybody else, basically. And on the US citizen side, you have people that are born in the US that are citizens by birth because they were born on US soil. And so that citizenship is by birth. You can also have US citizenship at birth if your parents were US citizens and met certain residency requirements before you were born. And so you could be, let's say, born in Canada and be born a US citizen if your parents were meet certain residency requirements and were US citizens as well. And those rules are complex and they change over time. But the birthright citizenship, being born physically in the US, that is in the Constitution, and that won't change. But the other rules about being born outside the US, those are subject to change. Congress can change how birth is transmitted, or how citizenship is transmitted at birth outside the US. The other major way you can become a citizen is through naturalization. And naturalization is a process where somebody who is not a citizen, somebody who has, let's say, a green card, applies to become a US citizen. And so it's an affirmative application that the person needs to make. Now, sometimes people can automatically be naturalized as well. For example, if a person is a permanent resident and naturalizes, his or her daughters and sons under 18 can also become citizens at that time. So it can be automatic in some cases, children of people who are naturalizing. The next major group are non-citizens. And so on the non-citizen side, we have lawful permanent residents. Those are people who are in the US with green cards. And that green card is basically just an identity document. And it shows that the person has the privilege of living permanently in the US and working in pretty much any occupation that they want to work in. So if somebody has a green card, they have pretty much all the rights as a citizen, except they can't vote. And the big one is that that privilege of permanent residency can be taken away by the government through what's called deportation proceedings or removal proceedings if the permanent resident behaves in or commits a crime, certain types of crimes, and that can lead to removal proceedings. So it's not concrete permanent residency, but as long as the person doesn't commit most types of crimes, then the person can stay here. The next big group of individuals in the US are people who are here as non-immigrants. And non-immigrants, there's about 70 different classification of non-immigrants in the US. Most of them do not allow for work authorization, but we'll address some of the ones that are available for work. So non-immigrants are admitted to the US for a specific purpose and for a specific period of time usually. And sometimes it's temporary in nature. Sometimes it can only be 6 months. Other times it can be for what's called duration of status. If a student comes to the US, they are given F1 status. And as long as they're making progress in their schooling, they can keep that status going. So it could be a few years, it could be 10 years, it could be even longer. If someone comes here as a high school student on the F1, they can stay here till they get a PhD, as long as they're making progress towards the academic goals. The next group of persons in the US are people here that don't have a pure non-immigrant status, but are here as temporary under protection. So a type of humanitarian protection. So we have people here as refugees, asylees, folks that are here under TPS, which is temporary protected status. We also have individuals that were brought into the US as children without status, who are now without a status, but have been given what's called deferred action for childhood arrivals. And that was a program by the Obama administration that basically allowed these children to stay here, who are now adults, by the way, and contributing to the community, work authorization, and sometimes privileges of travel as well. But that status is always under, it's a controversial status in some states. Some states have sued the federal government and said that the federal government didn't have a right to establish this. So it's not something that probably will be permanent in nature. For the time being, it's here, and hopefully it will stay. But ultimately, Congress will need to act on it to make it a statutory part of our system. The next big population group are people who are here without a status. And so these could be in about 10 million, it could be about 11, 12 million people in the US that don't have a status. And some of these folks came to the US without admission or without being inspected by a Customs and Border Protection officer. And so they were without status as soon as they arrived into the US. The other group are folks who came here on visas, let's say, and then somehow violated their status. So a student generally is not allowed to work off of campus, but if the student works, then they potentially lose their status, or if they stop studying, he or she can lose the status, and that person then becomes unlawfully inside the US and loses the status. Now, there's some basics about non-immigrant statuses, and it's good to kind of talk about them just so you have an understanding of who is involved in the immigration process. So there are typically 3 major agencies that are involved in this U.S. immigration law, and that's Department of Homeland Security, the Department of State, and the Department of Labor. So those 3 agencies are all major players in developing immigration policy. Now, Department of State's role is to issue visas, and that's basically what they do. They stamp visas and passports. So when we talk about visa statuses, it's not just the stamp in the passport, but also how they are treated once a person comes to the US as a non-immigrant. And that is controlled by the Department of Homeland Security. So even though a person has a visa in their passport, when they arrive at Logan Airport, let's say, they need to be inspected by a Department of Homeland Security officer who will admit that person into the US in a specific status. And what they can do in that status is governed by rules and regulations adopted by the Department of Homeland Security. So it's very important to know, that admission is governed by the Department of Homeland Security, while the visa can be, something that's issued by Department of State. And the reason why this is important is that once a person is in the US in a particular status, an employer can sponsor them to change that status. So typically what we have is individuals coming here as students and then graduating, and then an employer coming out and sponsoring them for a work visa status. And it is possible to do that as long as the student has maintained a status. In most cases, you can change that person's status, ask Department of Homeland Security to change that person from F1 to a work-enabled status. And I'm going to talk a little bit about some of the work-enabled statuses that we have here. Now, once you're here on a work-enabled status, you can also get an extension of status, and that's done through Department of Homeland Security. So oftentimes people say, well, the visa and my passport has expired, what do I do now? If they are maintaining a status, that stamp in the passport doesn't govern their stay in the US. Department of Homeland Security governs that. And usually DHS will, have procedures for extension of somebody's status in the US. Now, these are the typical work-enabled visa statuses that are popular with employers. There are other statuses out there, but they're sometimes very hard to obtain. And these are the most popular ones that are useful for most professional occupations. So on the top of the list, we have the H2B one, and I'll talk about that. There's specific statuses that are tied to someone's nationality. So H1B1 is slightly different, and it's just for Chile and Singapore. We also have TN, which is just for Canada and Mexico. So if you're a Canadian citizen, or if you have a Canadian or Mexican citizen candidate for position, you can use the TN in some cases. Madeline will talk about these visa statuses. We have the E3, which is just for Australia. It's very similar to the H1B, but just for Australia. We have the O1, which is very difficult to get because it requires a lot of documentation, and you need to show that the person that you're sponsoring for the O1 is really at the pinnacle of their field, of their profession. They're really at the top. And again, it's extensive documentation. We also have the E1 and E2 visas. Those are tied to certain countries that have national treaties of commerce and trade with the United States. There are about 80 of those, and we'll talk briefly about that. The J1 is what's called an exchange visitor program. Many folks are familiar with the J1, but you don't know that it's so common around in these parts. And so many of the universities use the J1 program for postdoctoral fellows. J1 is also a summer travel component of the J1. There's an au pair component of the J1. So the J1 can be used by many different types of organizations. You have to go through the Department of State to get the J1 visa program going, but it is a useful exchange visitor. It's pretty short term in nature and doesn't generally lead to a green card, so you would have to convert to a different status. And then we have the F1 for students. So once an F1 student graduates in a degree program, they can get what's called OPT, optional practical training, and that's work authorization for 1 year generally, not always, but usually. And then if they are a graduate of a STEM field, they can also apply for a STEM OPT extension and for 2 additional years. Now, there are some caveats and requirements for STEM OPT. The employer, you would need to be part of the E-Verify program, and you also need to develop a training program for the student. And I call them students because they are technically F1, students under immigration rules. They're already graduates though. So, when I refer to students, I mean in the immigration sense of F1. Now, H-1B, I'll talk a little bit about this. It's a very important program because it's really not tied to any nationality, and it's open to any specialty occupation. So it's a very useful visa to have and to sponsor individuals for. There are some basic requirements for it. Number one, it has to be in a specialty occupation. That's a job that requires at least a bachelor's degree in a field, in a specific field or a narrow group of fields. So for example, if you are an insurance agency and you want to sponsor someone for insurance sales and you don't care what kind of degree they have, as long as it's a bachelor's degree, it could be in any field, that will not qualify for an H-1B. But let's say you are an accounting firm and you have an opening for an accountant and you require at least a bachelor's degree in accountancy for it, then that is narrow enough and specialized enough to qualify as a specialized occupation or a specialty occupation rather. And so you would be able to participate in this program. Now, the other main component of the H-1B program is that you have to promise to pay this individual, the person you're sponsoring, at least the prevailing wage in the locality where you're going to employ that person. So there's some research that your attorney will do to make sure that the job offer you have complies with those Department of Labor rules. So that's a major component of this compliance component of the H-1B program. The next big issue with the H-1B is that you do need to provide notice that you're participating in the program through a posting that you place at the work site, but it does not require any kind of advertisements. So you do need to post so that your other employees know you're participating in the program, and you have to list the salaries that you're offering on that posting, but you do not need to advertise in the paper or on internet or anything like that. Now, of course, the last component piece of it is that the candidate you sponsor needs to be qualified for the job. So if you're sponsoring somebody for an accounting position and they don't have that accounting degree in hand at the time you're ready to file for them, then that case won't be approved. So you need to have the degree in hand at the time of filing. Now, there are some issues with entrepreneurs. And so if you're a budding entrepreneur and let's say you can do these types of activities on your student visa, on your OPT, and you're developing a company, or you're in partnership with a company that's founded by an F1 student, you can sponsor that individual under the H-1B program as long as you establish that you have a bona fide employer-employee relationship. And basically, that comes down to the employer showing that they have the right to control the employee and to supervise that employee. And ultimately, if things go bad, to terminate that employee. So as long as the company, the sponsoring company, can show immigration, US immigration, that they have this right of control over the person, it should pass the test as a bona fide employer-employee relationship. But it does come up as an issue invariably when there's a smaller company or when the company is fairly new. So you always have to keep that in mind. Now, the drawback of the H-1 program is that it's limited in number. Every year, the government releases 85,000 new H-1Bs. 20,000 of those are reserved for individuals who have at least a US master's degree or higher. And the competition is really intense for these 85,000 new visa numbers. Generally, in the last few years, we've seen 300,000 registrations for these 85. So it's less than 1 in 3 chance of getting selected. And so the government releases these numbers or visas on October 1 of every year, and employers traditionally can apply for them up to 6 months in advance of the need. So April 1 was always a major day for immigration lawyers because that's when they could file their petitions under this H-1B lottery. Now, the system has changed recently in the last 2 years. And so in the old days, before 2020, what we would do is we would submit full packages, complete petition packages to immigration so that they're delivered on April 1. Immigration would be flooded with packages. They would get 200,000, 300,000 FedEx envelopes with 200 pages worth of filings. Instead of doing that, and then they would select the 85,000 out of that and return all those packages to people and employers. And that was a huge waste in time and money. And so immigration has developed this new registration system. So instead of submitting full packages, the employers are allowed to submit registrations for the workers they want to sponsor, so the individuals they want to sponsor. And the registration is quite simple. We just need the name of the sponsored person, their passport number, their date of birth, some other data like that. And we submit that to immigration electronically. And then what immigration will do is on March 31, they will go through all the registrations and select enough that they think will fill the quota. And so employers will have basically the first 3 weeks of March to submit these registrations. It doesn't matter if you submit the registration on the first day of opening or the last day, they have equal chances of being selected. So we always get calls like, March 1 or 2, like, did you submit my registration yet? Yeah, it doesn't matter if it's on the first day of March or on the last day of the registration period, which is this year, March 18th. So as long as it's timely registered, you have equal chances of being selected. Now, this last year, what happened was immigration made the selections on March 31, and they reviewed the petitions that came in. Employers will have 90 days to submit the petition once they're selected. Not enough people got their petitions approved last year, so immigration did a second selection in June, invited more sponsors to file full petitions, and they did a third round in November. So hopefully, that will happen again, that immigration will do multiple selections. So don't lose hope. If your candidate doesn't get selected on March 31, there might be a chance they'll get selected again or at later on in the year. Now, Madeline will take over and talk about the rest of the program.
Thanks so much, Prasant, and hi everybody, and thank you for joining us. So I'm going to just finish up this section about temporary work visas, and we try to present it in the way that the information that an employer would want when they're trying to hire someone. And so this slide is about the free trade agreement. It used to be called NAFTA, and you may have heard of it, but now it's the US Mexican and Canadian agreement, and it's pretty much still the same as NAFTA. It allows people that are citizens, passport holders from Mexico and Canada, to enter the United States for up to 3 years and can work as a professional out of 63 occupations identified, going from, say, architect to science researcher, professor. So there are various occupations, and if the person qualifies, has the appropriate degree or license, education, then they can be admitted for up to 3 years. And we do get a lot of inquiries by employers, what do I need to do? What's the process? For Canadians, it's fairly straightforward. If the person clearly qualifies, they go to the border, either at the airport or a land border, present a detailed letter of an offer of employment, how the job fits one of the occupations identified under the treaty, and that they're coming in temporarily for up to 3 years, and some pretty good detail about the position. There are some tricky occupations where it would be good to consult with an attorney and make sure that the person won't have issues at the border because a Canadian could get denied at the border. The Mexican nationals have to go to their US embassy or consulate within the country, within Mexico, and apply for an actual visa stamp. Canadians don't have to get a visa in general for any visa category, mostly, but Mexicans have to get the visa. It's the same type of process, but there's this visa application and then a letter, etc., as I just mentioned for the Canadians. So that's the basics for if you do want to hire someone that's from Canada and Mexico, they may have this option. There are other categories similar to the H-1B based on nationality. There's the H-1B one if you have a candidate from Singapore and Chile. They do also have a numerical quota, as Prasant mentioned, for H-1B, but it's usually never reached, unlike the H-1B that Prasant just discussed. There's the E3 is a treaty for Australia, similar to the H-1B, where there's wage attestations, but again, a much more streamlined process with very low usage. So we're always excited when an employer calls us and it's one of these nationalities where we can maybe quickly do something to help the employer onboard a candidate from these countries. So now a big abrupt switch to green card. And it looks like a big divide, but basically many people that we assist that are on temporary visas want to morph over or change over or bridge over to the green card. These are the basic categories. There's employment-based immigration, family-based, diversity lottery that's held every year. I will talk about employment-based in more detail as well as touch upon family-based, but diversity lottery is held once a year and it's for countries that have low immigration to the United States. And we meet people, it's a free process that can be done online. Investment, you know, if you have maybe a partner that wants to start a business with you from another country, if they invest $1 million in the US and you're able to show hiring 10 US employees within 2 years of receiving a green card, that partner may be able to get an investor green card. Asylum refugee, always in the news, people fleeing from their country due to political belief, strife, social group. The key is that the person would have to apply for asylum within a year of entering the US. A refugee is done outside of the US. There are other categories that come up, like the big one of Violence Against Women Act. It's not just for women, it's for, if a person is facing abuse by a spouse, then they may be able to not depend on the spouse for the green card. They can take their own application forward if they can prove emotional or physical abuse. So these are just the basic categories for employment-based green card. It's divided, there's the Statue of Liberty in New York that says, come everybody, you're poor and everything, but there's really, come in a certain order. And the order is, the people at the top, people of extraordinary ability, the outstanding researchers and professors, or if you're a huge, an executive of a company, you can come in first preference, we call it EB1. EB2, a little lower tier, is master's degree or equivalent. There are 2 categories within EB2. If your person's immigration to the United States is of national interest. And then there's PERM. The vast majority of employers that have employees that they want to keep in the US and support for green card go through PERM labor certification. And that is basically testing the US job market. The employer has to do this to ensure that giving the green card to your candidate doesn't take a job away from a US worker. So the vast majority of employers must go through this PERM process. Then there's EB3, all people with bachelor's degrees or skilled workers, say a skilled Finnish carpenter, they also have to go through the PERM process, or the employer does for them. A lot of people say, well, my employee's on H-1B and they're asking about sponsorship, what's involved? And we usually set up a call and discuss the options that might be available. And this is basically the options for green card through employment. In terms of how it all works and why it may take 10 years to get a green card and another person 2 years, is because that there's an annual quota. Here's that word again, the quota. There are 144,000 green card numbers issued per year, divided among the different categories. But not one country can exceed immigration per year than another. So that's why there are significant backlogs in some categories for some countries. So for our work, we try to help with people planning and how long it might take. And the reason is, this is an excerpt from a chart that's issued every month that shows how long it might take a person to actually get their green card. When you see the word current, you know, the EB1, those people of extraordinary ability, the top preference category, if it's current, that means that person can apply for the green card very quickly. There's not going to be this big lag. But once you get into EB2, people with master's degrees or MDs, because there is more immigration from China and India, there are backlogs, and very significant ones, as you can see, for India. Meaning, if you started a process for an employee from India today, February 10, 2022, they actually will not be able to file their green card until February 10, 2022 or earlier, is shown in this chart. And right now it's January 1, 2013, which is just staggering, well over a decade. Not as long for people from mainland China, but still there are backlogs that develop continually. And the chart changes per month. So a lot of people say, well, why can't I just get a green card, or the person just sign up and get a green card? If it's through employment, they do face this issue of the visa bulletin. And that's why it can take someone, you know, more than a decade to get a green card. And all that time, that person has to maintain a status, say under H2B or some of the other temporary categories we talked about. Now, when we support people and try to help them plan, someone might say, well, gee, I'm getting married to a citizen. Is that going to make things easier? Well, certainly then we switch over to family-based immigration. And family-based immigration is based on close relationship, usually with a US citizen. So sponsorship by a citizen of a parent. The citizen has to be over 21 to sponsor a parent or a spouse, or an unmarried minor child under 21. And there's also allowance for a son or daughter, married or unmarried, or sister or brother. Now, the reason there's an asterisk next to parent, spouse, or unmarried minor child is that is called immediate relative, meaning there's backlogs in the family-based immigration also, like the employment-based, that can develop. So for example, sister or brother from the Philippines may take 25 years for a sister or brother to be able to actually immigrate to the United States. Whereas if you're an immediate relative, the citizen can file the petition saying, I'm the parent of the, the citizen's filing for a parent, and at the same time, that parent can file the green card. There's no wait. So fortunately, in 2013, same-sex marriage was permitted and recognized by the Immigration Service after the Supreme Court decision. And so same-sex marriage has been permitted for green card since 2013. Child also includes children adopted before 16 years of age, and stepchildren where a relationship was created before the child turned 18. So that's a really quick summary of employment-based and some family-based immigration topics. So we just wanted to allow time for questions, if there are any. So please feel free to ask questions. Thank you so much.
And thank you both for joining us today and making that presentation. We really, really appreciate it. Hi, everyone. For those of you who don't know me, my name is Michael O'Neill. I use he, him as pronouns. I'm the Administrative and Operations Manager for the Chamber, and I'll be helping moderate the Q&A. So if anyone has a question, feel free to pop it into the Q&A box. You should have that on your Zoom toolbar, which for most people will be on the bottom of your screen. You are welcome to ask questions anonymously should you wish. And I'll just give it a minute for people to type in their questions.
So I have a question while we're waiting.
Sure, go ahead.
How many members are there in the chamber now? Do you know, anyone know offhand?
313 as
Wow,
of
that's
yesterday.
wonderful.
So it's been a really interesting time. You know, we didn't really know what was going to happen once the pandemic
Yeah,
began. We had 98 members at the end of 2019, and we've tripled in size. So
fantastic.
uh, yeah, it's a good feeling.
Great.
Yeah, and I saw you guys are going out to Western Mass.
We
Nice.
launched in December. We have a dedicated position with Angie Montalvo Green, and our membership in Western Mass since Angie joined um, has doubled. So, you know, we're really finding that the businesses are out there, they need support, and it's once they hear about the work that we're doing and the support that we can offer, they're generally pretty excited to join and be part of the work. I have a question. So if you had to pick one main pitfall for an H-1B application, what would you say that is? What's the most common issue that you find with applications, either on the employer side or on the applicant side, or pro process wise?
Hmm. Well, for me, it seems that immigration, well, during the Trump years, they were very keen to try to deny H-1Bs because that was their anti-immigrant kind of ethos. And what they would do with the H-1B program is generally anytime you brought up a job that was, you know, they'd question whether it was really a specialty occupation. So that was the main focus as far as I could tell. How about you, Madeline? What do you think?
Yeah, I think for sure the prior administration across the board, they were challenging the H-1B. Now that it's a little more normalized, I think the challenge can be when you have an occupation that's not clearly requiring, let's say, a technical degree, maybe an administrator that someone wants to hire, where the degree may not be specialized enough to support an H-1B, just as Prasant mentioned, but you know, there definitely is a shortage of labor. And so I'm talking to employers where they say, can we just make, can we please, would this pass for H-1B? And it might not. I'm working on one for a PR consultant, and that may not be specialized enough to meet the H-1B requirement. So that can definitely be a challenge. Or if it's a nonprofit and maybe the pay doesn't meet prevailing wage, you know, that can be a struggle. Or a very small company where, you know, immigration may challenge it because it's a, you know, not a huge company. But, you know, the challenge will be that they would issue a request for evidence and we have to meet, you know, meet the challenge. So, but we usually vet our cases very, you know, obviously ahead of time to try to say, hey, this is going to be a pitfall or a problem.
And I think there's a question, right, Michael? But I'll just ask one other quick one because I know this comes up for our folks in Provincetown specifically when they need labor over the summer. Is there any advice that you can give specifically for those for the businesses that are seasonal? Are there things that are specific to them that you can share today?
Yeah, I mean, we didn't touch on the seasonal visas. So the H2B is the workhorse visa for seasonal business employment. And then the J1 program has the summer component that allows for college students abroad to come for summers. And so many employers rely on that program as well. As far as the outlook, the J1 doesn't really have a quota, but it's not open to every nationality, unfortunately, because it's based on certain types of countries bringing or being allowed to use that program. The H2B has a very strict quota, and unless Congress increases the quota, it's pretty rare for that to, for seasonal employers to meet the, their labor needs. But
Gotcha.
Madeline, yeah. Mhm.
Yeah, it's definitely a challenging category, the H2B, and it's just such planning is needed. And again, the quota, and there's a mini test of the labor market, and it's a gauntlet for an employer to get through that to hire. And I know the Cape and P-Town, all the restaurants are so dependent on seasonal workers. So, yeah, if there's anyone out there that wants to review and see, get in touch, but it's definitely a planning way ahead as much as possible.
Perfect. Yeah, I know I had questions from 2 of our businesses there, and we have other businesses, and I know that this is going to come up for them. I think they're facing issues already with trying to find staff even before the season, and so I think everyone is just really particularly concerned about what's going to happen come May.
Yeah.
So okay, perfect. We will definitely share your information with them. Thank you.
We do have a
Right.
question from the audience. Oh, sorry, did I cut? Were you about to say something else?
Just adding that, last year we had COVID and the year before too, and many of the embassies and consulates were closed. So it was hard to get H2B workers, even if the employer did everything possible to get the approvals from immigration. There was a brick wall with the Department of State. But that's it. Hopefully that'll change.
Absolutely. All right, so an anonymous attendee asks, how old does a child have to be to sponsor a parent?
Oh, I'm sorry if I didn't make that clear enough. The child has to be 21 to sponsor a parent. So that myth that all the people coming here to have a baby in the US and get a green card is not true. That baby has to grow to 21 years old. So.
But you'll be surprised how fast that time flies. So, when I started my career, I've had people come back to me when their kids are all grown up and ready to sponsor them. So it happens.
All right, well, that is it with that we have. Oh, excuse me. That is all we have for questions. If anyone has any last minute questions or thoughts, please pop them in now. In the meantime, Thais, shall we start to wrap things up?
Yes. Thank you everyone for coming today. Thank you for joining us for this webinar. Thank you both for being here. Thank you, Richard. I see that you're in the room as well. Thank you so much. Thanks to the 3 of you for suggesting this and for being here and for being a resource for our members. Nice to meet you.
Thank you so
well.
much. Thank you. Great to talk to you.
Thank you, everybody.
Bye-bye. Bye.
Bye-bye.